You can rest assured of your child's excellent performance when you register your child with Janan Schools, Bombo Kalule Campus and Kabalagala. Due to their firm educational background, we have the best facilities in both arts and sciences, fully updated to the latest sector standards, right from Senior 1 to Senior 6, in an environment that offers a chance to apply practical skills in all fields. That include a computer lab, introducing our students to the tech world, a well-organized science laboratory, a fully stocked library with all the essential books a student may need, a model farm to equip students with all the basic knowledge in agriculture, plus extra vocational skills. We promote co-curricular activities in sports like badminton, table tennis, basketball, volleyball, chess, and many more other activities. Register your child today at both campuses in Bombo Kalule and Kabalagala campus. For more information, contact us on the numbers below.
What is important is to agree in principle that any person, regardless of his position, to discuss an ongoing matter in court does so in abuse of the sub judice rule. Your Honor, once the order is issued, if any living person goes ahead and contravenes the order, then that person will be singled out and dealt with in accordance with the law. It is tried that an order of court is an order in rem. It is an order against the whole world. Once issued, a court order binds all parties and everyone, including bystanders, in respect of the matter under litigation. Finally, the reason we implore a court to bar the audio and video recording is because they are capable of publishing the facial and voice impressions, but most importantly, once an audio or video is published, any person can manipulate it for whatever purpose. And the author cannot be in control of how it is used. So allowing video recording would be calling for issuance of an order in vain, which will obviously be abused by third parties who may not be easily identified. The contrary, print media, no New Vision or Monitor or Bogeera has run the story and the author is so and so. Even when the author is not named in that story, Your Worship, the author is traceable and the law is clear. So any misrepresentation will be remedied through the print media. But going by my brother's reservations, we would also have no problem barring the entire media, including the print media, for the sake of protecting the integrity of this trial and the sanctity of court. You will have no problem, Your Worship. So submit.
The application of the land chief settlement and the reply of the land council. The state's prayer is that the court bars media houses to journalists from live coverage of the court proceedings. It has had a negative impact on the ongoing case. That individuals and some pastors across the country are now discussing, interpreting, and giving their opinion on this matter, which offends the sub judice rule. The land state attorney alludes to the security concerns of the parties in this case, the witnesses, advocates, court officials, and the integrity of this court. In reply by the land council for the chosen person, both Council Humphrey and Council Bernard concur with the state on the sub judice role, but submits that this court should not, bar specific individuals or pastors who are discussing the merits of this case that is ongoing, but should not gang or bar the media houses from professionally covering the trial. The Land Council for the chosen persons suggests some restrictions, like not covering the faces of the parties, but that they should be allowed to record and report accurately on this case. I have had the benefit of listening to the submissions of both sides. The gist of this application touches on the sub judice rule, that once a matter is before a competent court undergoing trial, no person or authority or a party is allowed to discuss, make analysis, draw conclusions about that matter until its final completion. From the beginning of this case, court allowed media houses to cover this case, for we believed that in a free and democratic society, the media as the first estate need to participate in this democratic process. But as time went on, it has come to the attention of court that these media houses, or people holding cameras, phones, and other gadgets, may have specific interests for which they record these proceedings for. This can be discerned by watching or listening to someone who, while preaching or addressing a press conference, is broadcasting live what transpired in court. Thus, court has seen some TikToks videos of several Ugandans creating or showing what exactly transpired in court, and also adding in their own information that they want. This court believes that it's not healthy and safe for the parties in court, the witnesses who come testify in this matter, the advocates prosecuting and defending this matter, and even the court officials ourselves. This live broadcast or creation of these social media accounts or social media accounts like TikTok, YouTube, live TV broadcasting, showing pictures of parties in court is a security risk for all of us. We have witnessed ugly scenes in this country where court officials have been targeted by ill-intentioned people. This court cannot sit and wait for the same results. I therefore find that the media houses or specific people with cameras in court recording, what they record is what gives these other groups of people and individuals a chance to discuss court business, which amounts sub judice. In light of the above, this court orders the following. 1. All media houses, cameras, phones, or any recording gadget are hereby banned forthwith from recording or broadcasting the proceedings of this court in this matter. Order number 2. An order is hereby issued. Anybody, whether as an individual or as a group, from continuing committing this sub judice rule. Number 3, this court will hold anybody, irrespective of the title, the rank, and position that someone holds, in context of the sub judice rule in this matter. Number 4, the media personnel who are verified first by this court are free to sit in and make write-ups of their story and publish in print media. Not video coverage, not audio recording. This court will evaluate the performance of the verified journalists as this case is ongoing and determine whether to ban them completely or not. It is so ordered.
I don't support anybody who is offending the sub judice rule. If there is anything offending the sub judice rule, then the court can really bar me. But the point to note that the prayers made by my land secretary, a court order cannot be issued against an entire warrant. A court order can never be issued against an entire warrant. It's very specific. To either parties or to either specific persons. Then another concern I have is that my land brother also says that it's only the print media and the authors who can be trusted. But even the video, should I call them the video media houses, can also be trusted. Somebody can trust NTV, can trust NBS, those who use video recording. But if there is anything that has so far been done that offends sub judice rule, then I would entirely agree with him that we should respect the proceedings in this court.
Your Worship, on my part, I'll also first of all agree with my friend harmful. That anybody that offends this rule should be categorical. That this has an impact on the proceedings before you. My only concern is in the aspect of barring the media, as the state seems to suggest. First of all, he indicates that he shared with us, and indeed we've had a discussion. And for me, as far as I see, the people that have actually been offending the subsidy school and have been identified are actually not media personalities. In fact, all the recordings are either on WhatsApp, on YouTube, or TikTok. There is actually no specific media house that has participated in having any discussion of these proceedings. But particular individuals, indeed some of them are pastors, some are agents of respective pastors, and some could be agents of the respective parties in this matter. So openly barring the media would be really unfair, because from the start the media has been reporting this matter. The only thing that should arise is that the media should be cautioned to publish accurately and not to make comment, personal comments or opinions. But they should be free to publish and attend proceedings. Your Worship, we at some point also made a similar prayer. And in fact, the state also himself found it that it would not be right to gag the media. So we can as well identify the specific people that are offending the subjudice court, that are discussing this case. But we cannot blanketly blame the media, because no media personality has actually been identified. I'm doing what my land friend is suggesting. I would agree that we can have restrictions, and indeed restrictions have been put before by this court. All that is left is enforcement of the breach of those restrictions. The idea that the proceedings being recorded by video or audio and the citation that print is better, Your Worship, there is actually no difference, provided they are publishing accurately. And all I can agree with is that maybe they could remove our faces for the security concerns that my lab friend has suggested. They could at the start, as we come in, they could have that record. But publishing the entire faces as officers of court and the court, as we submit, I agree. There can be a restriction on that. But as to barring the entire recording of the proceedings or audios, again, that would be unfair because they should be able to present actually